International Criminal Tribunal for the former Yugoslavia is now in session. L'audience Tribunal Penal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Good morning, Your Honors. Good morning to everyone in and around the courtroom. This is case number IT 0588T, the prosecutor versus Popović et al. Thank you. Sorry. So good morning, everybody. All the accused are here. The representation is as yesterday, except that no, he is here. Okay. Representation is full house today. Mr. Haynes is present. So, Ms. Favon.
Merci, Monsieur le Président.
Thank you, Mr. President. The prosecutor acknowledges that President Karadzic gave the order of the Krivaya operation directly to the Drina Corps. Yet the prosecutor alleges that the main staff was informed of the order of the Drina Corps on the 2nd of July 1995. On the basis of these two presumptions, the prosecutor infers that General Milatic had knowledge of the order of President Karadzic and he received the order of the Drina Corps. First of all, those are only presumptions. Colonel Lazic was not certain how the main staff was informed of the order of President Karadzic. In fact, he was not certain whether the main staff had been informed. In the collection of the Drina Corps, no telegram informing the main staff of the order of General Karadzic was found. Also, there is no trace of any transmission of the order of the 2nd July 1995. Incidentally, General Milatic is not the main staff. Even if one supposes that this information was transmitted to the main staff, this does not mean that they were automatically transmitted to General Milatic. The order of President Karadzic may have been given directly or reported directly to General Mladic. It could have also been transmitted by a go-between or the duty officer. The onus probandi lies with the prosecutor. The knowledge of the information concerning military activities around Srebrenica, and in particular the order of the 2nd July 1995, is an important fact. The prosecutor should have established beyond any reasonable doubt that General Milatic had received this information. Yet he did not do so. No evidence in the case file permits to reach such a conclusion. Indeed, if such information were destined to General Milatic, it should have been found in the reports to the main staff. These reports do mention the preparation of combat activities, but they contain no information indicating in the many reports, preceding reports of the Drina Corps and of the main staff, and in particular the report of the 16th of May 1995, P2892 and P2896. The reports of 2, 3, and 4 July were not drafted on the basis of the order for the combat activities or on the basis of an order of President Karadzic. They were drafted on the basis of the order received from on the basis of the reports received from the Drina Corps. Let's take as an example the report of the main staff of the 4th of July 1995, P3164. The sentence quoted by the prosecutor in the footnote 4150 concerning the closing up of the enclaves is lifted from the report of the 4 July 95, 5D 906. The closing of the enclaves was not a new task for the Drina Corps. It was its permanent task, which appears from all the work plans of the commander of the Drina Corps, as shown by 5D 991 to 5D 995. No particular knowledge of the General Miletic of the actions in which the Drina Corps was going to be engaged on the 6th of July 95 appears from the reports drafted by General Miletic, who on the 7th of July 95 was going to Belgrade to spend some time in his family.
Le procureur n'a
The prosecutor has adduced no evidence that General Miletic has taken part in the making of decisions concerning the changes of the initial plan and of the entering in of the VRS in Srebrenica. Indeed, as I just said, at the time, General Miletic was not even at the main staff. During the hearing on 2nd September 2008, the prosecutor stated that he did not deny the alibi of General Miletic, and he considered for his case that the alibi was proven. The defense has no obligation to prove the alibi. The defense is simply obliged to present evidence giving rise to a reasonable doubt as for the evidence adduced by the prosecutor. It behoves the prosecutor to set aside the reasonable hypothesis which the alibi is true, or to prove the alleged facts despite the alibi invoked by the defense. The decision to enter Srebrenica was taken on the 9th of July 95. P33. No evidence exists that General Miletic would have had any knowledge of this decision before he heard that the army of the Republika Srpska had indeed entered Srebrenica. Also, nothing in the case file shows that General Miletic could have known that such a decision was going to be made, or that he could have foreseen it. Now, this is the decision which changed the course of the operation. General Miletic was completely unaware of it, just as he was unaware of the order of the 10th of July 95, P181. Simply, he was not present at the main staff. We consider that General Miletic was not the member of a joint criminal enterprise, and he had no knowledge of the decision of the 9th of July. He had no way of knowing the possibility of foreseeing the possibility such of opportunistic murders. The prosecutor had difficulty in explaining how General Miletic could have foreseen such murders and gave no explanation for this. The appeal chamber therefore decided in its recent decision in the Karadzic case that the possibility for a crime to be committed must be sufficiently substantiated to be foreseeable for the accused. Without knowing that the army of the Republika Srpska was going to enter Srebrenica, General Miletic had no way of foreseeing that the population of Srebrenica was going to take refuge at Potocari. The conditions at Potocari, separating the men and their detention at Bratunac, Gravica, and Petkosi, was completely unforeseeable for him. Therefore, he could not foresee the possibility for the alleged acts in paragraph 31 of the indictment. The allegation of the prosecutor, according to which General Miletic was at the center of the decision-making process in the period which followed the taking of Srebrenica, is always totally unfounded, and the evidence cited by the prosecutor do not confirm this. I shall not repeat the arguments concerning the document of the 13th July 95, P192, because we have already put them in our closing brief, paragraphs 508 to 513. but I would like to say a few words on the alleged participation of General Miletic in the drafting of the order of the 13th July 95, P45. The prosecutor cites the decision Netelkutia. The declaration of Netelkutia was based exclusively on the fact that this order bears number 03/4 of the 11th of September 2007, page 15183. Yet, Netelkutia admitted in fact that he did not know who had written this order, page 15215. Document P45 bears number 03/4, just as practically any other order of the main staff. In 1995 and up to the 17th of July 95, General Miletic was the only officer in charge of operational matters in the main staff, since Ljubio Bradomic was on sick leave. Simply stated, he could not have drafted alone all the orders given by General Mladic, General Milanovic, and the assistants of the commander. The order of the 13th of July 95 bears number 03/4-1629. This number 1629 means that as from the 1st of January and until the 13th of July 95, the main staff had given 1629 orders, 1629 orders. So an average of 8 to 9 orders were issued every day from the main staff. 03 or 3, well, 4 of the. Even if one assumes that General Miletic did nothing else, he was not able to draft alone every day 8 to 9 orders. The prosecutor admits that officers of other bodies were part of operational officers, were involved in these operations. The officers were certainly quite capable of drafting orders when they were on duty. Those officers, just like duty officers of subordinate units, the corps and the brigades, were not subordinate to the chief of the body in charge of operational matters, but to the commander or the person who stood in for the commander. This is 7D442. Besides, the defense of General Guerrero does not challenge that General Guerrero gave orders bearing number 03/4 in their final brief, page 94, footnote 408, and page 209, paragraph 297. The defense of General Guerrero has acknowledged that General Guerrero had given the order of the 11th July 95. This is Exhibit 6D207. This order of the 11th of July 1995, 6D207, bears, just as the order of the 13th of July 95, the number 03/4. In order to prove that General Miletic had taken part in the drafting of an order, the prosecutor should have adduced the evidence showing that General Miletic had indeed done so. The prosecutor cannot show that General Miletic was the only one drafting the orders in the main staff, and no evidence shows that he would have taken part in the drafting of the order of the 13th of July 1995. The defense of General Miletic does not challenge that the logistic body of the main staff could have been involved in certain logistic aspects of the activities of the Drina Corps in July 95. But General Miletic had no part in this. As we indicated, General Miletic is neither the main staff nor the commander of the main staff. He has no need to know basis of the activities of the main staff and may not therefore be responsible for it. I would simply like to add that in the allegations of prosecutor in paragraph 297 of that closing brief concerning the bombs, the air bombs, the prosecutor alleges also at the footnote 674 that General Miletic was involved in the transportation of such bombs, the air bombs. Quoting document 5D 976 and the testimony of Dragica, neither the testimony of Dragica Marshal nor the document 5D 967 have any connection with the Krivaya operation. And document 5D 976, which is the order of General Milanovic of the 30th of May 95, and the testimony of Dragica Marshal concerned the Operation Spreadshaw. Milo Gavric, chief of the artillery of the Bretonage Brigade, stated that these bombs, although provided for in the brigade order of 5 July 95, were never used. Just as there is no evidence implicating General Miletic in the logistic affairs, prosecutor did not deduce any evidence that would have involved General Miletic in the mobilization of the buses. The case of the defense concerning the conversation intercept concerning fuel on the 12th of July 95, P111, are expounded in our closing brief, paragraphs 418, 483. This P111, 1111. In his interpretation of this intercept, the prosecutor, supposing that Miletic was mentioned in this conversation was General Miletic, is only interested neither in what Miletic did nor in what he said. He's not even interested in what General Miletic knew. For him, it is enough that somebody whose identity is not known would have contacted him. If the Miletic mentioned in this intercept is General Miletic, this conversation, contrariwise to allegations, shows exactly the opposite of what the prosecutor wants to demonstrate. It shows that General Miletic has in no way contributed to the supply of fuel and that he did not even knowledge of this, because in any other case he should have reacted to the request of fuel which he received, and he did not do so. Indeed, there is no evidence that General Miletic has had any role concerning the events which followed the fall of Srebrenica until the Muslim column created a military threat in the area of the Zvornik Brigade. Although we consider that the actions taken with the intention to military combat the column do not feature in the indictment, I would like to make a few remarks on the conclusions of the prosecution which are unfounded. Could we please go to closed session?
Let's go into private session for a short while, please. Open session, thank you.
Supposing this conversation did take place, is it really so important to know whether it took place on the 14th or the 15th of July? Well, of course it's important. The whole case of the prosecutor is predicated on this conversation, which would have given General Miletic, in the evening of the 14th July 95, the information concerning the column and the situation in Zvornik. If General Miletic ever had such a conversation, he certainly didn't have it on the 14th of July 95.
We have set out our arguments regarding conversation connected with extension 155. This was P1164. and with the conversation a certain General Popović may have had, P1166, in our closing brief, paragraphs 530 to 540. Nobody in this case has ever managed to identify General Popović. Regarding extension 155, this extension could be anything, anywhere. But if it is the extension of the main staff, it had to be established at least who was in the operations room in the evening of 14th July of 1995. There were always many officers in that room. There was duty officers for sure, and witness Sasha Jovanovic did confirm that the assistant commanders could have been there. He said so on the 6th of July 2009, transcript pages 33949. The possibility that General Milicic might have taken up the phone on extension 155 is only one among many other possibilities that are equally reasonable and plausible. Many other officers could have taken up the phone on extension 155. To conclude that it was General Milicic is certainly not the only reasonable conclusion. The way the conversation between Malinic and Nastic, which is P1168 on 14th of July, is also wrong. If the prosecutor is to be believed, Zoran Malinic gave instructions to Nastic after speaking with General Milicic. The words put into Malinic's mouth by the prosecutor were indeed spoken by Nastic, because he was the one who gave instructions to Malinic. Even if you think that this conversation was true, which has not been confirmed by other evidence, this does not support the prosecutor's case. Nastic did not speak with General Milicic, and the instructions he gave, which were incorrectly attributed to Malinic by the prosecutor, have no link whatsoever with General Milicic. If you analyze the events and the conversations of the 14th of July 1995 correctly, you will see that on that day, General Milicic did not have any information as to the situation prevailing in the Drina area of responsibility other than what he could read in reports. The report of the main staff for the 14th of July 1995, P48, literally passes on the information provided by the Drina Corps in their report, which is 4D84. If General Milicic had other information, he would have put it into the main staff report, just as he did on the 16th of July 1995, P50, when he had received information from other sources. General Milicic informed the Zvornik brigade of the arrival of the Krajina Corps brigade. This is not an order, it is a piece of information drafted after an agreement with the 1st Corps commander. But beyond these rather technical observations, is it possible to see in this document an unlawful act, an unusual act, or a piece of a document that should not have been written? No, this document is a military document that was written with the unique objective of fighting the Muslim forces. And we're not just speaking about the column that left Srebrenica. We have in mind also the 2nd Corps forces that attacked the area of the Zvornik brigade on the northwest front. This is 5D303. This was the testimony of Ostoja Stanisic on the 17th of May 2007. Transcript pages 11713. The dispatch of reinforcements to Zvornik on the 15th of July was a militarily justified act. This is the only possible conclusion. No criminal intent can be inferred from this act. When General Militic passed on the information regarding the dispatch of the Ukraina Brigade to Zvonik, he had not the slightest idea of what was really happening in Zvonik. He couldn't even imagine that the members of that brigade could later on be involved in criminal acts, of which, incidentally, General Militic is not accused, and that were totally, in all respects, inconceivable for him. The only acts that could be ascribed to General Militic on the 15th, 16th, and 17th of July 1995 are all linked to the military threat that was represented by the forces of the ABRH, by the column, but also by the Second Corps forces. Regarding the allegations of the prosecution that General Militic had knowledge of murder executions, this is way beyond the scope of the indictment. But beyond that, the prosecutor's conclusion are implausible constructions devoid of any evidence. The reports General Militic received at the time were very vague. They were also contradictory, and none of them managed to describe the situation properly. General Militic was not in the field. He was not in the area of responsibility of the Zvonik Brigade. No information regarding the thousands of Muslims that had been captured and detained ever reached him. The only thing that was reported to him was the fact that a large number of Muslims had surrendered. In a fighting situation, a large number can amount to several scores of prisoners. Neither General Militic nor the Administration for Operations and Training had any authority regarding prisoners. General Militic could only include this information in the reports drafted by the main staff. This was his obligation, and this is what he did. He could not imagine for a single moment what was the fate, what could be the fate of these prisoners. Once again, General Militic is not the main staff. He did not receive all the reports sent to the main staff. He received combat reports. The reports on intelligence mentioned by the prosecutor in paragraph 1702 of their brief were not addressed to General Militic. Document P149 was not even sent to the main staff. Documents P147 and P148 were sent to the Administration for Intelligence, the intelligence sector. There is no evidence to confirm that General Militic ever saw them. There is no evidence to show that General Militic should have seen them. Just as he was not involved in the Srebrenica events, General Militic did not take part in the JEPA events. General Mladic was in JEPA, and so were some of his assistant commanders. It is obvious that those who were in JEPA knew the situation in JEPA much better than General Militic, who was not there. The only knowledge he had was derived from the reports he would receive. With regard to the report of the 65 Protection Regiment that was sent by telephone, it was about the activities of the said regiment on their base in Rijeka, where the unit was in charge of securing the main staff. These reports did not contain any information about JEPA. The latter was to be found in the Drina Corps reports, to which one unit of the 65th Regiment had been resubordinated by way of an order given by General Milovanovic on the 21st of May 1995. This is Exhibit 5D 1214. Admittedly, during the JEPA operation, General Milicic did receive some requests from the field, but these documents do not amount to any evidence of his contribution to the JEPA events. Very simply, to put it very simply, there is no evidence that the requests addressed to him were ever followed up. There is no evidence to suggest that General Tolomir received the communications equipment asked for on the 14th of July. This was P183. There is no evidence to show that the military police of the 65th Regiment requested by General Krstić on the 20th of July, this was P3015, ever made it to JEPA. There is no evidence that the proposals made by General Tolomir and sent on the 21st of July, P2794, were ever implemented. The defense has set out their arguments about the conversation between General Mladic and General Krstić in their brief, paragraphs 568 to 572. Let me just say this. Exhibit P3058, which, so the prosecutor alleges, confirms the content of the conversation, shows indeed that contrary to the prosecutor's allegation and contrary to the content of the conversation, throughout the day on 17th of July 1995, the Muslims turned down the conditions offered by the Serbs. Indeed, General Mladic would not have the meeting at the airport, but the negotiations between the Serbs and the Muslims, mediated through the UNPROFOR, carried on after the refusal, and an answer was expected the next day at 10 o'clock. Within the context of Exhibit P3058, the content of the conversation that bears the number P1231 is totally unlogical. On that day, the 17th of July, Colonel Terkulja returned from Zvonik. Zvonik may have been the reason why General Krstić had to contact General Milicic. Zvonik, JEPA, and why not the Drina Corps unit that was on the Sarajevo front? Why not the reports that General Milicic had been expecting since December that are mentioned in conversation P2341? JEPA is certainly not the only possible topic of this conversation. There is no evidence to substantiate the conversation between General Mladic and General Krstić. There is no evidence that General Krstić ever contacted General Milicic. May I remind you of the testimony of witness PW147, who testified that at times the events that would follow a conversation were exactly the opposite of what had been said in that conversation. Indeed, after the prosecutor corrected their allegation about Colonel Miljanovic, and after the conversation about the conversation of 24th of July, the only link between Milicic and JEPA remains Exhibit P190, a report by Colonel Karanovic on the 25th of July. Contrary to the prosecutor's allegation, this exhibit does not show that General Milicic talked to General Lugonia. Regarding the conversation with Mr. Bulajic, this exhibit does not allow the inference that General Milicic spoke with him or whether he was just present during the conversation. The conversation with Mr. Bulajic is about negotiations carried out by the RS Commission for war prisoners with Muslim authorities. Such negotiations are nothing uncommon. They should have been useful and constructive. Their purpose was not to transfer population, it was to look for a solution. General Milicic's participation in the conversation with Mr. Bulajic does not mean that he contributed to the JCE, let alone that he had any intent to do so. General Smith went to JEPA. He participated in the negotiations. He was far more involved than General Milicic was. However, it never occurred to anyone to say that General Smith would have participated in forcible transfer. The only difference between General Smith and General Milicic is that General Milicic was a member of the UNPROFOR, whilst General Milicic was a VRS member. The fact of belonging to the VRS is not enough to infer General Milicic's criminal intent. But nothing, not a single shred of evidence, would prove that General Milicic, throughout his service in the VRS, throughout the war, including in 1995, ever acted with a criminal intent. General Milicic was not in Srebrenica. He was not in Žepa. He lacked any specific information related to these events, and above all, he had no influence at all. General Milicic knew that General Smith was going to Žepa. He knew that the international organization were in Žepa. How could he assume that acts that can be characterized as criminal acts may have happened there? Of course, the mere presence of international organization does not remove the criminal character from the act of transferring population. It is just that General Milicic was not there, that he had no accurate information regarding these events. He could not know that criminal acts could have been committed. In his view, the fact that there were international organizations there was a guarantee, an assurance that the laws of war would be complied with. All the acts of General Milicic were perfectly legitimate, were carried out as part of his duties. Of course, a legitimate act that was accomplished as part of somebody's duties can also contribute to a criminal enterprise. But at any rate, it must be established that the act had been carried out with criminal intent. Yet, the evidence adduced at trial does not allow any such inference. The acts that could be ascribed to General Milicic would have been carried out by any officer in the position of the chief of the main staff operations and training. Any officer in charge of operations would have done exactly the same as General Milicic, and no officer in charge of operation would have done anything else. Mr. President, Your Honors, you don't have in front of you the entire army of Republika Srpska. You do not have the main staff in front of you. You do not have to make any determination on the duties of the chief of the administration for operations and training. You have to make findings as to General Milicic's responsibility. He was an officer who, as part of his duties, took part in drafting Directive 7. But he was also the officer who did not transmit the final text of that directive to subordinate units. General Milicic was in a position to sign notifications regarding convoys when General Milovanovic was absent. He had no influence whatsoever on the decisions that were made, but he knew that the convoy would not be allowed through if he did not send a notification. General Milicic was not the person whom it was impossible to bypass in the main staff. The entire Krivaya operation took place whilst he was on leave. General Milicic did not take part in making decision. He had no influence over General Mladic. He wasn't even directly subordinated to him. He was subordinated to General Milovanovic. This trial went on for over 3 years. Several thousands of exhibits were admitted, but there is none whatsoever showing a meeting between General Mladic and General Milicic. There is no evidence or suggestion that a proposal was ever made by General Milicic to General Mladic. There is no evidence of any specific contact between General Milicic and General Mladic. There is nothing. But for General Mladic's speech that failed to mention as people being among his close Associate General Militic. He's a discreet and decent officer. He's an officer who never expressed in a conversation, an interview, or a speech the slightest animosity or bias towards ethnic communities. General Militic was also a moderate officer that General Mladic sent for the first time to a meeting with the UNPROFOR in September 1995, when the balance of power had shifted and when General Mladic had to display cooperation and moderation. Mr. President, Your Honors, the evidence adduced at trial fails to establish General Militic's responsibility. The prosecutor failed to establish beyond reasonable doubt that General Militic had any criminal intent. Therefore, General Militic must be acquitted of all charges. Thank you very much.
Je vous remercie aussi pour le temps additionnel.
Merci.
Thank you very much.
Judge Kwan, Judge Stoller. Judge Post. None of us has any questions for you at this stage, at least. We may have later on, after having heard everyone. So, yes, Mr. Gosman.
Mr. President, I had the opportunity last evening to review the transcript of yesterday's proceedings. And with your kind permission, I would request the opportunity to supplement just 3 of the answers that I gave you yesterday very briefly, certainly less than 6 or 7 minutes. And I understand that we actually came in under our time allotment by about half an hour.
It's okay. Go ahead.
Thank you, Mr. President. Mr. President, I'd like to begin with a question that was asked by Her Honor Judge Prost, who asked, and I apologize that I don't have the official page references, but Judge Prost asked, let's presume that there is a conclusion reached that at least 2 members of Mr. Borovchanen's unit had custody, just for the sake of argument. And then a question followed about the legal implications of the Merksich decision. I should at that point have presented to you, first of all, a factual issue. And that is that by the time Mr. Borovchanen arrives along the road, one of those 2 men is dead and the other has left. So I suggest to you that in respect, at least of those 2 individuals, custody cannot be attributed to Mr. Borovchanen because one is dead, one is gone. That's the first argument. But this leads to a second question, which I believe was interrelated to the question that Her Honor Judge Prost was asking, or at least it is in substance. And that was the President's question being, and I quote, why would there be those 2 specials and no one else from the specials? And I have 2 submissions on this. First, I simply wish to draw your attention more specifically to our brief at 190 to 192, where I more fully set out the substantiation to the answer that I gave yesterday. But much more importantly, even if you're left in doubt about why those 2 individuals were there, and we respectfully submit that if you are in doubt, that doubt must be resolved in favor of the accused. But even if you were to decide otherwise, I suggest to you that there is a huge body of evidence that you need to consider in addition to just the absence of a why in determining whether or not that is a safe inference. In fact, we devote a substantial portion of our brief precisely to addressing that wider context so that you can assess whether the remainder of that unit can be inferred to have been there just on the basis of the presence of those two individuals. And that evidence is summarized in the bullets presented at paragraph 369. And I simply refer you to that paragraph because it conveniently summarizes the evidence that precedes that paragraph. The third question that I would like to address you on is Judge Stolle's question, which I must say I did not answer particularly well, having gone back and looked at the transcript. He asked a particular question in relation to a sentence that appears in the middle of paragraph 330 of our brief. And the sentence is, Popović had no duty as a superior to make any inquiries into what was going on in the warehouse unless his men were present there. Let me try to explain what I meant by that. Article 7.3 requires a commander to ensure that one's own subordinates are not committing crimes. It doesn't give rise to an open-ended obligation to inquire as to whether non-subordinates are committing crimes. And Popović did make inquiries as to whether his men were committing crimes. And I refer you to paragraphs 328 to 330 of our brief, where we do set out the inquiries that he did make at that time and subsequently. We argue there, and we believe that it is reasonable for you to accept that it was reasonable for him to rely on what he was told at that time, given the context. And this is a fact-specific inquiry. Given the context, it was reasonable for him to rely on what he was told. And in that respect, again, the contextual factors that make it reasonable for him to have relied on what he was told are expressed at that paragraph, 369, in the bullet points, but also as illustrated in Annex F of our brief, which shows you where his units were along the road. So the basis for the claim that is being made in the middle of paragraph 330, to answer this question very directly, is that's a factual claim based upon what we know of the evidence. That's not intended to be a legal claim to suggest that there was no duty to make those inquiries. He did make those inquiries. And for completeness, I would also refer you, in addition to paragraphs 328 to 330, also to paragraphs 336 to 338, where further inquiries and explanations are documented. Thank you very much, Mr. President.
Thank you, Mr. Gosnell. Judge Post, Judge Stoll. Okay. Now, do you need some time to, no, okay.
May it please your honours, it's now our opportunity to address you on behalf of Milan Guerrero. Your honours, I'm going to start, then Mr. Popović is going to take over a little later on, and then I'm going to take up where he leaves off. Let me begin by saying that making closing speeches used to be my bread and butter. Prior to my arriving at this tribunal, over a 20-year period, I must have given literally hundreds of such addresses, both for the prosecution and for the defence. These were in front of magistrates, judges and juries in trials that lasted from as little as 1 hour to as long as several months. Trials in relation to a whole range of criminal allegations, from the very minor to the very serious. The problem, Your Honours, that I face today is that I'm somewhat out of practice. I've worked at this tribunal for over 4 years, and I have never in that time given an address like this. I can only hope that in the next hour or so, I will learn that making a closing address is a little like riding a bicycle, something one can always do once one has learned how. A truism, of course, that has been confirmed to me by living in the Netherlands. The main reason I'm emphasising this at the beginning of my address is not to ask you to excuse my lack of organisational skill, which all around me know only too well, or even my lack of eloquence. It's that you forgive me if at times I sound like an old broken record, as I address a court endlessly about the basic tenet of any fair system of criminal justice, namely the burden and standard of proof. This is in part because old habits die hard, and such a theme would be the central part of any such address that I have given in the past. But it's also because it's a subject that I feel is worth spending some of our valuable time upon today. And in one sense, let me say, I feel a little like Mr. Stojic. He said he was somewhat apologetic for having mentioned the subject at all, because like him, I appreciate that this trial chamber is very familiar with this concept. I appreciate it will always be in the forefront of your minds, that you are professional judges and that you neither need nor appreciate being lectured by counsel on this important subject. But the simple fact, we suggest that with the best will in the world, it's all too easy to get it slightly wrong and misapply this vital principle. During the course of the addresses we've heard over the last few days, we've seen that. And simply by way of example and illustration, I would like over the next few minutes to highlight to you how easy it is to get it wrong. And I'm about to give, if I may, a random selection relating to various accused in this case, and they're purely in chronological order. In fact, the first, my learned friend Madame Favreau just referred to a few moments ago, but I make no apologies for making the same point as she has just done. At 34072 on the 2nd of September, Mr. Thayer was addressing her case, and he said, obviously, from our position during trial and in our brief, we're not contesting in any real way General Militich's quasi-alibi of being in Belgrade from the 7th through the 11th. Let's assume that it's been proved, just for the sake of argument. Well, Your Honours, quite what Mr. Thayer meant by we're not contesting in any real way is, to put it mildly, somewhat obscure. But leaving that aside, he's got it wrong. He said, let's assume that it's been proven. Well, of course, Militich doesn't have to prove anything at all, least of all an alibi. 2 pages later, Mr. Thayer says, you have to ignore a mountain of compelling testimony to come to the conclusion that Dutchbat was sitting on that much fuel at that time. We say he's wrong. The defence do not need to establish any such conclusion at all. The opposite is true. You'd have to be satisfied beyond a reasonable doubt that the only conclusion was that Dutchbat were not sitting on that much fuel. At 34083, Mr. Thayer's addressing my client's case. And he says, The Guerrero brief would literally have you believe. This makes it sound, we suggest, like we have a burden, something we have to prove. Let's make it clear, Your Honours, we're not seeking to make you believe anything at all. The only purpose of our final brief and these submissions is to contend that the prosecution have failed to discharge their heavy burden. If we suggest anything at all, it's literally in that context. The following day at 34181, Mr. Elderkin's addressing a Guerrero defence factual point about a particular alleged opportunistic killing. He says, it is not reasonable to draw any conclusion. Again, we suggest it's the wrong test. The defence have no burden, nor are they seeking to persuade you to draw any conclusions at all. On the 4th of September, Mr. McCloskey is addressing Mr. Borovchanin's case. And he says, it was full of unreasonable conclusions. Again, we'd suggest the wrong test. But he goes on a line later and he says this: we absolutely stand by, as we always have, the legal proposition. If there are two reasonable interpretations of circumstantial evidence, one in favour of the defence and one in favour of the prosecution, the court must go with the version in favour of the defence. Now, Mr. McCloskey makes it sound like some sort of equal contest. Perhaps he doesn't mean quite what he says, but we would suggest it's misleading and, at the very best, a simplification of what is a vital topic. At 34239, Mr. McCloskey says, the fair inference you should make is... Again, wrong test, we suggest, Your Honours. The only inference is the test. From the prosecution's point of view, if it's anything less than the only inference that you can act on in the prosecution's favour, then it's not an inference that you can draw adverse to an accused in this case. Even my learned friend Mr. Gosnell, in his tour de force on Wednesday at 34573, got it wrong when he said the defence side are required to discharge. Of course, the defence are not required to discharge anything whatsoever. And finally, I hope she'll forgive me, but Madame Favreau, we suggest, got it wrong yesterday when at 34648 she said, it suffices, she's talking about the defence here, for it to adduce evidence showing that another possibility is reasonable. Well, of course, the defence don't have to adduce any evidence at all. Now, Your Honours may say that these are slips of the tongue, and in some cases, no doubt they are. Some may be stylistic, and some may be translation, interpretation, or that type of error. But we suggest that they do indicate how easy it is to enter into a general misconception as to exactly what the burden of standard of proof is and what the words beyond reasonable doubt mean. And when prosecution advocates were saying these particular things, perhaps they weren't considering quite what these words mean and the extent to which they apply to this and any other case. Now, before I move on, simply because it fits conveniently into this part of my address, I'd like to deal with another similar point that arises in the prosecution final brief. And it's been alluded to in one form or another, I think by both Mr. Burgoyne and Madame Favreau in slightly different context. But so far as Guerrero is concerned, at 1765 of that brief, the prosecution say Guerrero would have participated in the drafting of Directive 7. We suggest, Your Honours, that the words by the drafter of that sentence would have give the game away. The writers of the prosecution final brief are native English speakers, and they could easily have said Guerrero participated in the drafting of Directive 7. because they know they don't have the evidence to support that proposition, subconsciously or otherwise, we suggest, they put in the words would have. And in this context, the words would have fall short of beyond reasonable doubt. We make a similar point in relation to paragraph 1760. Returning to where I left off a moment ago, it's a basic principle that the accused doesn't have to prove anything at all. The presumption of innocence means precisely what it says. It does not mean, and excuse me for putting it this way, that the prosecution are entitled to say, somewhat emotively, these are terrible crimes, there are lots of victims who require justice, the accused in question has a close connection with the army who committed these crimes, look who this accused associates with, this is all terribly, terribly suspicious, dodgy, fishy, call it what you will. The accused must be guilty. Or put another way, unless the accused comes up with some compelling explanation that sounds correct, then he must be guilty. Your Honours, we suggest it's all too easy to slip into that way of thinking, particularly in a case that centres on an allegation of quite literally the murder of thousands of people. Now, if you'd excuse me, I want to broaden this out very slightly and look at this particular topic in a slightly a different way and in the context of a trial by judge rather than jury. Because as you're no doubt aware, juries are viewed as sacrosanct in many countries. But even their staunchest defenders would have to admit they have one very significant drawback, and that is they give no reasons at all for their decisions. And it's here that the parties to this case, both prosecution and defence, have a distinct advantage, we suggest. The parties will learn the reasons why a trial chamber has come to its various conclusions. This, of course, provides a very important safeguard. The judgment and its various conclusions will allow the parties to know how the trial chamber has evaluated the various witnesses it has heard, as well as the other evidence. But of course, such evaluations, and in particular conclusions, need to be within the context of the burden of standard of proof. The parties will be able to see why a particular witness, in whole or in part, has been relied upon by the trial chamber. It's a basic tenet of the system that this is a very unequal battle. I say a very unequal battle because it's heavily weighed in favour of an accused person. Because, and excuse me for stating the obvious, for you to rely on a witness or a piece of evidence in the prosecution's favour, you would need to be satisfied beyond reasonable doubt that that piece of evidence or witness was correct in that regard. Of course, to rely upon a witness or a piece of evidence in an accused's favour, there only needs to be some reasonable possibility that what the defence assert about that piece of evidence is in fact correct. We suggest that one needs to be realistic about this, because it follows that in this or indeed any other trial, there are highly likely to be very many issues that a trial chamber in its judgments are actually unable to determine. What do I mean by this? Well, on any given issue, if the trial chamber are left in any reasonable doubt about the issue, then of course they have to give the benefit of that doubt to an accused. Now, addressing this full on and being, for want of a better expression, adult about it, this does not mean for one moment that the prosecution case on any hypothetical issue is wrong. Indeed, it may well be right. Many occasions it probably is right. Equally, it doesn't mean that a defence case on a particular issue is right or probably right. Indeed, it's wrong or quite probably wrong. But if there's a reasonable doubt, that always exercises in favour of the accused. We venture to suggest that this leaves a trial chamber in a long, complicated case like this in some difficulty. Realistically, the desire and certainly the temptation in a judgment is to try and make a series of factual findings so as to, in effect, tell an account, dare say a historical account of these events, and then fit the accused into the picture. But we would venture to suggest that it's not like writing a report on these events in the way that NIOD were able to, or indeed the way that the Secretary-General was able to. It's not like writing a historical account in the way that various books one can buy in a shop read. It's actually, we would venture to suggest, much more difficult, as it's far more disjunctive. Now, Your Honours, I appreciate that when I'm saying this, I'm addressing judges who have had the experience of writing judgments at this tribunal hitherto. But nonetheless, I persist with my point. The problem we suggest that the nature of the system at the ICTY is in fact totally inimical to this type of fact-finding. And it's inimical to that because in order to say that any fact, and we quite literally mean any fact is established, you've got to be satisfied beyond reasonable doubt that the prosecution have proved it. And to repeat what I've said, this is actually highly unlikely on many contentious issues. Common sense simply dictates that you are going to be left in doubt, that you're going to say, well, we think that this probably happened, or yes, this has been proved on the balance of probabilities. But we have to accept that a reasonable doubt has been raised, and it's simply not clear in terms of a criminal judgment what happened in regard to this specific issue or fact. And without labouring the point, it is of course no coincidence that the two verdicts open to you in relation to any count on this indictment, in relation to any accused, is guilty or not guilty. That's not guilty and innocent, and that of course is no coincidence. Now, some may think that these submissions are not at all attractive. I suspect some would say they're very unattractive in the extreme. Because not only does it leave things in limbo, it leads courts to being able to make findings that are most probably true, but have not been proven to the requisite standard. This has all sorts of repercussions. Repercussions to victims who are not getting the justice they deserve. Political considerations that we all know about. And to address this issue head on, and excuse me for saying it, it leads to men who are most probably guilty of extremely serious crimes actually walking free. Now, lest anyone think I am suggesting for one moment that that is the case with any of the accused in the dock in this case, I'm not. My submissions are entirely theoretical, but they apply equally to all cases at this tribunal and to many other jurisdictions as well. And I've been at pains not to give any specific examples, save the mistakes of some of the advocates over the last few days. But I said a moment ago that these submissions are theoretical. They also happen to be true and central to the system of justice that you have been given the heavy responsibility of administering. It's a heavy burden you face, we suggest, in, among other things, dispensing appropriate justice, applying the burden standard of proof in the proper fashion. I started the first section of my address by saying that I hadn't made a closing speech for over 4 years. That may be true, but one thing I have proved to myself is that old habits do die hard. Because I would never have had the guts, and some would say been so foolhardy as to address a jury in this way, to look them in the eye and say what I have just said to you. We suggest that is the advantage of professional judges. And that advantage is the most important aspect of this criminal justice system, and we trust will be reflected both in your deliberations and your judgment. Now, moving on from that, I've already alluded to the impact what I've had to say has on witnesses. Assessing the credibility of witnesses is an essential part of your task. Obviously, the burden and standard of proof is vital here. I've already made some reference to it. If the prosecution rely on an assertion or piece of evidence of a witness, particularly if it's unsupported by any other piece of evidence, then you can only act upon it to the detriment of the accused if you're satisfied beyond reasonable doubt it's true and correct. As I've already said, the opposite isn't the case, and I won't repeat the point. Mr. Burgoyne put the dilemma you face in this regard very well, we would suggest, at 34486 lines 4 to 15. In a trial such as the present one, the dilemma that he sets out is particularly acute because a number of the witnesses whose credibility even the prosecution question. The prosecution have rightly cautioned you, both in their opening and in their final addresses, as to how some of the witnesses, in this case, need to be treated with great care. The prosecution, as I've already pointed out, and I make no apology for saying so again, don't really remind the trial chamber how this isn't some sort of equal level playing field when sizing up these witnesses. The defence have the enormous advantage for the reasons I've already alluded to. Now, a practical example of this, again, I think Mr. Burgoyne dealt with, and he's to some extent taken away my thunder, because he dealt with assertions or submissions made by Mr. Mitchell when he was dealing with Mr. Popović's case at 34151 in relation to the witness Achimović. Now, obviously, this witness has absolutely nothing to do with General Guerrero's case, and again, I'm just showing this as a good illustration of what I mean. The difficulty the trial chamber has with a witness such as Achimović is to determine the fact from the fiction. The difficulty is all the greater when, if you're going to use what he says against an accused, you're going to have to be satisfied beyond a reasonable doubt that what he says is true. Whereas the opposite, of course, is not the case. I've already made the point several times. Now, Mr. Mitchell, in fairness, goes on in his submission and makes some attempt to explain why Achimović is reliable on the issue in question. And I'm not going to get into that. But it's a very rare, perhaps the only example in this case, of where my learned friends sitting on the other side of this courtroom have sought to help you in that way. They fail to do that lamentably. They leave you in a complete state of quandary as to how you're meant to size up the conflicting and contrasting interests of these particular witnesses. In this regard, I'd mention a further comment of Mr. Burgoyne's, in fact, on the same page at 34486. He said this: "We are confident that the trial chamber will have no difficulty in identifying the credible and reliable witnesses amongst them." Now, Your Honours, with the greatest respect, and I mean what I say, we have absolutely no doubt, that is the Guerrero defence, that you will try your very best in this regard. But we do not really share Mr. Burgoyne's confidence. It's not that we don't trust you, because the same point applies to all tribunals of fact, all courts. But the reality is, it's often very difficult to discern when someone is telling the truth, when they're not, when they're lying, when they're trying to obfuscate. And it reminds me of a story when I was a law student. Part of my studies were trips to courts, and I remember going once with my group of fellow students to a court. I think it was a civil court, it wasn't even a criminal one. And when the litigants left, the rather elderly judge turned to us students and he said, I was at the bar for 25 years, and I've been on the bench for 20 years. And what depresses me is that after all this time, I still can't discern when someone is telling the truth. And it's a little anecdote, and excuse me if I'm giving evidence, but it's no more than stating the obvious. Because it illustrates the difficulties we suggest you face, particularly in a case like this, when witnesses have so many differing motives for telling the truth, for lying, and something in between, as I've already said. Now, I've made some remarks a little earlier about professional judges and the advantage to an accused. One of those advantages is we are confident that when you say in your judgment, we are satisfied beyond reasonable doubt that witness A is telling the truth, that you will state why that is. We're satisfied this witness is truthful because of X, Y, and Z features. That way, an accused knows precisely why a piece of evidence by a particular witness or an assertion by a witness has been relied upon. And that particularly applies, of course, if you choose the testimony of a particular witness, the pick and choose method that the prosecution are inviting you to embark upon in relation to so many of the witnesses they've called. Now, this has a particular application to one witness in the Guerrero case, and that's General Milovanović. Both the prosecution and the Guerrero defense in various parts of their brief rely on him quite heavily. In paragraph 55 of their brief, the prosecution say that Milovanović, quote, was evasive and less than candid, end quote, about Directive 4. Later on, they say that this document, quote, would have incriminated him, end quote. And then they say his testimony should, quote, be regarded with great caution on this point. But the prosecution brief elsewhere is literally peppered with references relying upon him. As far as we could make out, there were 61 such references as to where the trial chamber should rely upon what he was saying. And as I've already said, not a word from the prosecution as to how you should weigh this out, how you should deal with this, why he's reliable in relation to these 61 references, but not in relation to Directive 4. Nothing of any assistance to you in that regard. And, Your Honours, I'm going to say it once again, but the defence can have it both ways in relation to this. The defence are entitled to say, yes, if what he's saying may be true, some reasonable possibility it's true, we rely upon it, you act in the defendant's favour. If, on the other hand, it's adverse to the accused, it's got to be beyond reasonable doubt that it is true. We can have it both ways, and that's what we invite you to do when you come to deliberate. And General Milovanović is pretty well like every Serb insider, to use that slightly ugly expression, but one which conveniently allows us to know the type of witness we're talking about. We suggest all of these witnesses need to be treated, to use the prosecution's words from paragraph 55 of their brief, quote, with great caution. In passing, I should say that the prosecution pretty well did the same in their closing arguments. At 34060, they said he was unreliable, and on 3 occasions thereafter they rely upon him. But as I've already said, don't help you at all as to how you should weigh this up, how you should deal with it. Now, to state the obvious, but I will very briefly, Milovanović was by common agreement the second most senior and powerful officer in the VRS. For reasons that some might find hard to fathom, he has avoided prosecution. He has every motivation to shift the blame, subtly or otherwise, to his subordinates, including Guerrero. He has every motivation for obfuscation and basically avoiding the truth. Could I, before I leave this topic, just mention one other thing? Slightly different point, but it's related. I'm not going to review other witnesses who fit into the same category we suggest as General Milovanovic. But when making your assessments of some of these witnesses I have described as Serb insiders, please be very wary, particularly in relation to some of the lengthy re-examinations or redirects conducted in 2007 of their own witnesses by the prosecution. And please bear in mind those re-examinations in the light of the appeals chamber decision of the 1st of February 2008, titled Decision on Appeals Against Decision on Impeachment of a Party's Own Witness, where to some extent the procedure adopted by this trial chamber was said to be wrong by the appeals chamber. And bearing in mind those re-examinations were conducted under your guidelines, just treat those passages with the utmost caution. We would suggest as well that the prosecution had a deliberate policy of waiting and having these extremely long re-examinations, some of which went on for many, many hours, improper re-examinations. I accept you ruled against us so far as that's concerned, but that particular decision is important when you come to weigh up that evidence. Perhaps that would be a convenient moment, Your Honours.
We'll have a 25-minute break. Thank you.
All rise for your overview.